of questions. You're saying, so Dan, you said that it's best to anchor, right? Do the anchor, which is the motion record or whatever. So let's say that they also put in their responding record first, and then they decide to change things around. Would that mess you all up too? Wouldn't that mess you? So would it be a good idea for the counsel to kind of get together and maybe have an agreement and say, hey, just to make our lives easier for both of us, for the anchoring documents, let's not shift things around.
Yeah, I absolutely think you should do that. I don't know, I can't really remember, but I'm pretty sure that if the other side deletes their evidence that you're linking to, both systems will get messed up. Like your hyperlinking that you've done through Caselines will also have nowhere to go, and your hyperlinking in your factum will have nowhere to go. So you want to, deleting your evidence causes the other side and yourself a lot of work because they have to hyperlink again. I still think it's way faster to re-hyperlink this way,
right?
Even though you would have, because then let's say you had to hyperlink it this way, you would delete your factum off the Caselines to re-hyperlink it. But you wouldn't be deleting your motion record because that's there and it's on its own and all that stuff, right? So you would only have to delete your factum to do that, right? So, look, I don't think it's perfect. I think Caseline's got a lot of problems. I know, and we talked about this case in our last set of videos, and there's been more cases since. If you do not have an easy to navigate record in court, you're going to be in trouble. The links have to be there, whether they're the Caselines links or links put into your factum. You have to have it because, if a judge can't find what you're looking for, you're just dead in the water.
Yeah, and I do want to add something that I've frequently seen lawyers do as a mistake is uploading scanned version of documents that aren't searchable PDFs. Because if you scan the document and you don't make sure you convert it to a searchable PDF, when you go to search in Caselines for a word or page number, it's not going to read the document. So make sure that you're either converting a Word document into a PDF, or if you're using a PDF that's a scan, that you use a software like Adobe to convert it into an optimized PDF. So that's important.
That's
a good point, and I'm pretty confident that that's in the practice directions as well.
It's just something that like a lot of older lawyers, they've gotten comfortable with scanning their documents and uploading the scanned versions. And it has issues, particularly that one.
Right. I have another question that kind of popped in my head. So nowadays, I think I hear that some courts are going back to in-person hearings. Do they still use Caselines even though it's in person? So you can't get away, right, from using Caselines. Is that right?
Well, it depends on the judge too. Also.
Oh, interesting.
So what I understand, and I was very surprised to hear this because I work out of the GTA, mostly in Toronto, and in Brampton and sometimes in Newmarket, is that so where we are, everything's Caselines. There's no such thing as paper. If you're a tree around here, you're safe. Okay, everything is Caselines. If you go to court, you bring your laptop with you, and you're dealing with Caselines on your laptop. And I haven't done that yet. Everything I've done is still all Zoom. I haven't gone to court post-pandemic and done anything in person. But people have, and that's what they say. It's very different in other regions. So I was talking to someone the other day from Kingston. They're still printing and sending in document books as well as, and it's going to depend on the judge which version they want to use, and that creates page numbering problems. It creates all bunch of problems, but that's how they're doing it. Other regions, I'm sure they have their own different ways of doing things as well. Court of Appeal doesn't use Caselines. Ontario Court of Justice doesn't use Caselines, right? So it's still a little all over the place, but for the Superior Court in the GTA, which definitely uses Caselines, and Divisional Court, which a lot of people are using, my guess is that's what we're doing. We're not going back. We're not going back to paper ever.
Did you just say the Court of Appeal doesn't do Caselines? So
no, the Court of Appeal just No, it does PDFs. You just send your motion record and an email, and that's it. Or your appeal book, sorry, in an email, that's it. You just navigate it like you were on Zoom. Maybe you want to share a screen, maybe you don't, but there's no case line. You just tell people page numbers.
Oh, and one last question is this idea of practice directions and notices to the profession. So what happens if you don't follow? For example, you mentioned that there's that sequence, right, of documents in the notice. So if you don't follow it, does that mean you're going against the rule, and then your pleadings get struck or whatever, or your arguments get, like, what happens? So what is the question? So what if you don't follow the practice directions?
Well, okay, I think there's two parts to that question. One about practice directions in general, and then that specific part of the practice direction. Practice directions in general, if you're just like not going to comply with them, and you appear before a judge as a stickler for case lines, then you might get a note in the endorsement saying that counsel didn't make it easy to navigate, and I was unable to. You might get insulted in the endorsement.
Okay.
I don't think a judge will. You would have to really offend the practice direction for the judge to not hear the motion or have the hearing. If you just didn't sequence your documents in the divisional court according to the practice direction of factum first and then the record second, I can't see that being an issue. But if you go to a court, and let's say you're a superior court, just regular motion, and you upload a motion record that's not hyperlinked, that has no bookmarking, that is not searchable, and you're in front of a judge that is very comfortable with case lines and computers, you're going to get some kind of notice, a noting from the judge, and it'll either be like oral or written. But I don't think that you can get away this time, like in 2023, with not understanding how to use the technology.
Maybe would the judge adjourn the hearing so that you put those links in? Did they do that?
No, I don't think so.
Oh,
yeah. Okay. I agree with Heather. I think it's also depends on what part of the practice direction we're talking about. I think judges, from my experience, right, and again, as we move forward, judges expect more from people with this stuff. But in my experience, they're still very lenient when it comes to this electronic, documents and stuff. People are still getting used to it. As long as you can, navigate those documents easily and it's not a mess, then I think you're okay with that portion of the practice direction. But practice directions need to be followed, okay? It's very important that you understand this. If you go to some court in somewhere in the northern part of Ontario, there's going to have a different practice direction than one in the GTA. And if that court says you have to have in their practice direction, confirmation of motions, this is just an example, is 5 days, and you're used to Toronto where it's 2.5 days. I don't even know what it is in Toronto.
No, it's 5 days. It's funny because the lawyers who started practicing before the pandemic, we were all used to the 3-day rule,
3 days,
before 2 p.m. And now it's basically the default is 5 days.
Wow, 5 days.
Jurisdictions
if it's in the practice direction and you get something like that wrong, you will not go to court that day. They will not put your motion on the list.
Right.
So maybe this part of the practice direction, the judge will say, well, okay, they tried their best. Another part, you're done. Right. And it's because the practice directions are there to facilitate the efficiency of the workings of the court. If all the clerks or all the registrars or all the whatever they are working on a 5-day sort of timeline to get a motion into the judges, and if you're not there with your confirmation in 5 days, you're not going to get it. But on this other hand, they're a little more lenient. So follow the practice directions, right?
And note that 5 days is less than 7, and anything less than 7 has a special way of counting. So don't think just because you have the 5 days, remember it's a trick.
Yes, so we did Heather, you and I did a video on that 2 years ago, and I'm going to do a link here. And so if you guys missed that video, just click on the link above, and that will take you to how to count time. Okay, any last words, you guys?
I'll just give one extra tip just because it's on my mind right now. So we've talked about a lot of things today, but one of the things that we're supposed to be talking about the most was linking in your factum. Okay, so if you are everything's linked and everything's nice in case lines, and you get to your hearing. Okay, we're here at the hearing day. I just want to give a little tip that I like to use when we're there. So all the links that we've done in our factum so far have been for the reading of our factum. It's not necessarily for use in our factum, right? So when that judge is writing their decision or getting prepared for the case, all those citations are linkable. But what do we do when we're at the hearing and it's time to actually present our case, right? So one of the things that people do is they make a compendium. Okay, so a compendium is a separate document that has all the documents you plan to use in your oral argument, and that is maybe just excerpts of those cases you plan to talk about, just snippets of evidence that you plan to point, all again linked and all that kind of stuff. And even with case lines and all these links and everything, judges are still, they want compendiums more and more and more. Okay, but if you don't have a compendium, I want to point you to the Schedule A of your factum, right? So if you're looking at the rules of civil procedure, it says a factum should have Schedule A, and a Schedule A is a separate page at the end of your factum where all your cases that you refer to in your factum are listed. Okay. Now, I want you all to hyperlink your Schedule A as well. Okay.
Okay.
Now I'm going to share my screen with you. So when you're at court and you're about to talk to the judge, you say, Justices Heather and Justice Heather. Okay. I want to take you to the most important case there is, and it is the Municipal Property Assessment Corporation v. Loblaw Properties. For ease of reference, justices, go to page 884 on the master and just have that in front of you. And that is going to be a guide to the cases I'm going to talk to you about today. And then they can just go there and you can click through these cases just as you talk. And it is a nice little bookmarking for them in your oral argument. And that's another thing just to prepare it in your factum before it gets uploaded to case lines.
Have you done a case line, like a key number sheet, like numbers for key documents? Like, have you done that before?
I haven't done it where I uploaded it, even though it's a suggestion to do that in the quick or whatever it is. I have that with my preparation, right? So I don't need it. I don't find that I need. Like, I just tell the judge, I'm talking about this. I have it in my prep page, this and that, whatever. So I can just share the screen with them, or I can just point them to it or direct them to it in the direct feature as well.
Okay, I have done it before and it wasn't used. So I just
that's
annoying.
Yeah.
But that's why the compendium is sort of like, that is the most bare bones compendium you could sort of imagine, which is just links to where you want to talk about. To make that a little bit more fulsome, you would have the link and a cut and paste, right, of what you're actually talking about. And if you want to be like even fuller compendium, you would put those pages in. And I'm saying, from what I've heard from judges and what I see in decisions and what I see in updated practice directions and whatnot, they want more and more compendiums. I feel like that's counterintuitive. I feel like because it's so easy to navigate, you shouldn't need a compendium because we can just point everyone there. But they want the compendiums, and I think it's because people are doing such a poor job of making their stuff easy to navigate that the judge just wants to give it to me in a little pack so I can see it myself just easily.
And do you have any like recommendations for the compendium? Like, should counsel be putting in excerpts of the part of the affidavit that matters, or excerpts of case law? Like, or is there a way you've seen it where you thought this is very impressive and lawyers should copy it, this method?
I think it all depends on your argument. If you're going to talk about, if you're going to point to evidence and you're going to, and you're going to show the court, the picture of the bloody glove or whatever it is, then have that there. Say, just go to my compendium, page 1. First thing I'm going to show you, bloody glove. And this is where it is in the record. The link is to A4006. And then after we see the bloody glove, let's just take a look at his hand that fits. Next page. On the compendium, there's a picture of the hand. But this is on page PDF page, Caselines page be 4 million and whatever, right? So you've just streamlined everything, and it's only going to be depending on what your argument is, if you're what you're talking about. And as we know, you could have your argument scripted out to the word, and a judge will just knock you right off because they're going to want to start talking about the bloody shoe, and you never even anticipated that, and it won't be in your compendium, but you better know how to get there quick, right?
Right.
So,
yeah, I'm sure the next our next set of videos will be on how to use Chat GPT for your hyperlinking.
Yes, I was actually going to ask you guys. Yeah, Heather, you read my mind. So thank you guys for coming in today, and thanks everyone for watching. And by the way, before I let you guys go, I just want to give a shout out to Dan and Heather, because I wanted to let you guys know that they do offer private legal coaching services, and the information is on the Litigation Help website. So don't forget to check that out. Thanks for watching, and we'll see you at the next time. Bye.
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 Okay.